All right, are you Deshaun Robertson? And this is cause number 25 DCCR 0914. Ms. Robertson is charged with aggravated assault with a deadly weapon. Mr. Wilkerson has filed a motion asking that I reduce Ms. Robertson's bond, currently set at $300,000. And Mr. Wilkerson, you may proceed.
Yes, Your Honor, and in this case, just so the court's aware, there are several family members present
Okay.
who likewise could testify as to family support within the community, length of time in the community and community activities. What I would note, Your Honor, and what I would apprise the court is that even as of now, having received HIPAA releases from Ms. Robertson, we are in the process of receiving records from Spindletop and Fannin, Your Honor. We believe that condition can be fashioned, even if the court wanted to go so far in this case as home arrest. Your Honor, the truth is that because of some of Ms. Robertson's issues, she has had problems sustaining employment at times. I believe, if I'm not mistaken her, that she actually qualified for SSDI, but of course now that is stopped because she has been incarcerated, and she does have 2 children. One, I believe, is about to graduate.
I have one that's just graduated. He's going to the service, and I have 2 that are in school, in high school still.
And okay, so that was my misunderstanding then about the one that she was hoping to see graduate and obviously go off to the military academy. Your Honor, she does have, of course, the assistance of Miss Wynn, who is her mother, who is here, and also Miss Stewart, who is her aunt, is here, and then some of her children's here. Children are here, and even one of their significant others. Judge, this particular case, there are obviously some underlying issues. I think it just makes it a lot easier for us to be able to prepare this case and to undertake the evaluations and potential treatment necessary with regard to the matter. I can understand, of course, the court's reluctance to lower the bond given the severity of the incident, but I would hope that even perhaps Mr. Nichols might be able to throw some considerations out there that might include things like house arrest or GPS only that might give the court some additional comfort in terms of safety to the community.
So let me get some where would you live if you made bond, Ms. Robertson?
I have a house at 5555 Davis Drive with my kids.
5555 what?
Davis, THAMES Drive,
Who lives at that house?
me and my kids.
Which kids specifically?
I have
That's okay.
the 18.
Okay. If it were a situation, Your Honor, where the court would prefer, of course, that she live with her mother, I believe that's a situation that could be worked out as well. She's willing to, I believe, take on that responsibility.
What about Spindletop? Is there a plan in place for you seeing it going to Spindletop before this incident?
Yes, ma'am. I need to get back on my meds, to get back on my medicines.
So had you stopped going like you were supposed to?
Yes, ma'am. I had medicine to last, and then my caseworker ended up leaving, but I don't drive that far, cause I'm scared to get on the highways and stuff, so I don't drive. I only know the north end of Beaumont.
So it's our understanding that there had been a lapse in treatment, Your Honor. I won't know more until, of course, I'm able to access those medical records, which I just secured releases for, so.
Mr. Nichols,
Judge, my concern is the severity of this case. She hit a man, ran him over in the car, left him pinned there when she got out and fled.
what is his status?
He was in ICU. This case has only been indicted for 2 weeks, so I do not know his current health condition. I think he's been released from the hospital. I know he was able to give a statement to the police, and I will be in contact with him to see really where we're headed.
Okay. For the courts, for the record, I am reviewing the probable cause affidavit. There is only one incident at the jail, so that's not something that's of great concern. But well, actually it is of concern. Do you know why it's of concern? It's because it has to do with your medication.
It's blood pressure medicine that I was taken off of. I have a new prescription, and they keep trying to make me take it. I've been on that med since I was 19 years old.
So you thought the appropriate way to handle that was by writing F off on the medical stuff?
No, ma'am, it wasn't appropriate, and I did apologize, and I haven't had any incident with me since then, and I did give them my med doctor information so they can get the correct medicine into the jailhouse instead of having me on the wrong medication, because I was told to stop that.
You get a whole lot more being nice than you do acting like that, don't you? All right, so what I'm gonna do is grant the motion to reduce the bond. Going to reduce the bond to $100,000. A condition of that bond is that you are not allowed to drive any vehicle ever for any reason while this case is pending. Do you understand? Whatever that means as far as where you live, if you need to live with mom because you're not allowed to drive, then that's what you need to do. I'm not real worried about that. But I think if you're not driving, I also am going to order as a condition of that bond, if you make it, that you immediately make an appointment with Spindletop, that you follow through with any assessment, recommendations, medications. If you're not doing that, and I want proof of that, so you have to get proof. I want to know when your appointments are. I want to know what the outcome is. You have to get all of that information to Mr. Wilkerson so he can get it to me. If I find out that you've missed an appointment, that you're not taking medication or whatever it is, then that bond's going right back up and you're going to be in custody where I know everybody's safe. Does that make sense? Mr.
No
Nichols?
contact, staff premises.
Obviously, no contact whatsoever in any way with
Lyle Sanders.
Lyle Sanders. You're not to go anywhere near 3215 Gulf Street at Tulane, wherever this happened. I don't know who lives by there or why you were there. Doesn't matter. You can't go around there. Do you understand? And this goes, don't send messages through anybody else. Nobody needs to be contacting him or his family or anything like that. Let all that go through your lawyers and they'll handle that. But don't send messages. It's not beneficial for her if y'all send messages or anything like that to him, okay? If you're caught doing that and I find out that anybody's tried to contact him on your behalf or you contact him in any way, bond goes up. Obviously, we have another big issue. Does that make sense? Anything else?
I think that should suffice, Your Honor.
All right, you can go back with the bailiff.
Thank you.
Thank you, Judge. I believe that's the last.
Sir, are you Larry Fletcher?
Yes, ma'am.
And so, Mr. Fletcher is on probation and cause number 21-37809 for the offense of possession of a controlled substance, a second-degree felony. That probation is from October of 2021. It was a 5-year deferred probation. And then it looks like we have 2 new offenses that have been indicted in cause number 25, DCCR 0838, an aggravated assault with a deadly weapon, and 25 DCCR 0839, a manslaughter charge. Mr. Wilkerson has filed a motion asking that I set a bond in the motion to revoke case.
Yes,
Is
Your
there,
Honor. Mr. Fletcher.
hold on, is there any motions in the other two, or we're just talking about the,
I believe the state filed a motion seeking to actually increase the defendant's bond.
in which
Your Honor.
case?
Your Honor, I filed in both cases. In the MTRP, we filed a reply to the defense counsel's motion to set a bond. And then in the other two cases, the state, the aggravated assault and the manslaughter case, the state has filed motions to increase those.
Let me get that all pulled up real quick and then we'll get started. Hold on. I'm printing. I need to see all that. I just printed the response in. It's okay. We'll get it.
It's all your fault.
That's all. It always is. In my mind.
I'm used to taking.
In my mind, it's always my fault. Are the PCs, I guess, would be the same in
For
the manslaughter and the ag assault? So I'm
Ag
just
assault, they
printing.
came out of the same transaction.
Okay.
Occurrence, Judge.
Give me just a second.
Yes.
Hold on. All right. So there's no bond currently set in the motion to revoke. The bonds in the two new cases have been set at $50,000 each. So I've got a motion to set a bond in the revocation, and I've got a motion from the state to increase the bond and or modify conditions in the two new offenses, correct?
Yes, Your Honor.
Okay. With regard to well, I guess, Mr. Coleman, you mentioned that you would be willing to stipulate to some things before we get started with witness.
I suspect Mr. Wilkerson will call these witnesses to talk about the length of residency and the ties in the community, those kind of perfunctory things. If he will shorten this proceeding, I'm willing to stipulate to those if Mr. Wilkerson.
I mean, to some degree, that is some of it, but obviously there are more intricacies involved, including the nature of the family, the length of work, things of that nature that I think all need to be put into play here.
And I don't mind hearing the evidence. I don't want to hear the same thing. They're here, and I appreciate they're here, and I'll take notice of that. But what I don't need is to hear from all of the witnesses the same thing about work and living and all that. So if you want to call one or two that have that information,
Absolutely.
that would be great.
Yes.
I just don't want it to be the same thing, and I'll take notice that they're here and that they would all say typically the same thing, as if that's what it is.
Looks like he's on bond on 2 of those cases. I'm calling the bondsman right now.
Yes, he is.
He's already on bond. They filed a motion to increase the bond.
That's correct. So he, obviously this very tragic accident occurred one evening. There is no allegation of any substance use on the part of Mr. Fletcher contributing to the accident that involved the death of one of the victims and the severe injuries to the other. There is some, I guess the state's theory seems to be on the manslaughter, that he was reckless in his driving on that evening, thereby causing the death of another in the course of that reckless behavior while driving, which then makes it a stretch when the state then moves on to an aggravated assault charge for the second occupant of the vehicle, because of course if there were the intent and knowing element present there of course would have been a murder charge associated with the death of the first occupant of the vehicle. We are not debating obviously the tragedy of this incident, Your Honor. Mr. Fletcher, on the night in question, was actually responding to a work call. That is the reason that he was out on this particular evening. It was not after curfew, it was work related. He works for Ryder, the truck company, Judge. He's a mechanic. And as the court's aware, several years ago, Mr. Fletcher had an issue with substance abuse. Unfortunately, that's an issue that affects far too many people in the community, our loved ones, or sometimes ourselves, our family members, parents, sons, brothers, sisters, children. But Mr. Fletcher has been serving his probation faithfully. He has been supporting his defendants, Your Honor. He is engaged to be married. He has custody of his biological 2 children, and then also takes care of the 2 current children of his fiance, and is now welcoming a 3rd child. They are expecting that child. Mr. Fletcher has employment to return to, Your Honor, in terms of while these matters play out in the judicial system. Obviously, there are, the state seems to highlight Mr. Fletcher's driving record as a reason to change or deny bond in conjunction with the possession charge, which he is entitled to bond on. With regard to the driving record, I would simply say if that driving record, that, by the way, I have not seen certainly a certified copy of any driving record of Mr. Fletcher, but I have no reason to doubt Mr. Coleman's representations regarding that. There are certainly rules that the court could fashion. Obviously, Mr. Fletcher has a large family here supporting him, who have also been very supportive of the Thomas family since this tragedy. The allegation has to do in terms of Mr. Fletcher's fault in that death and that aggravated assault, which seems like a mighty jump in mens rea there, Your Honor, seems to be that he was traveling at such an excessive rate of speed on the night that when the person who disregarded the traffic safety device and entered a lane, failing to yield right away, Mr. Fletcher then did not have sufficient time to react and stop the vehicle because of his rate of speed, Obviously, we haven't had an opportunity to have our own investigators take a look at any of that evidence to be able to argue it at this point in the case, Judge. I only mention it so that the court is aware of the background context under which these allegations arise, and the sole issue at present right now in the defendant's or in the defense's opinion is whether or not to provide Mr. Fletcher a bond on the charge for which he was serving a deferred adjudication sentence and for which he has not been convicted, thereby, of course, making him eligible for bond in such case. Obviously, Judge, the law has changed in a number of ways, and if this were a case where Mr. Fletcher were some violent person, prone to violent outbursts, aggravated assaults, as the state alleges one of these was, although I just don't understand how you...
I'm not gonna get into the legal, I mean, they filed what they filed, that'll be a question for later, so.
The issue here, Judge, is whether or not to grant him bail while the allegations that form the basis of the revocation of this bond come to be addressed by the court. Your Honor, as I mentioned, and I would like to put his fiance on just briefly, his mother as well. And
Let me stop everybody. Here's what I'm inclined to do. I am inclined on the two new cases, the ag assault and the manslaughter, to in part grant Mr. Coleman's motion and modify the bond conditions. I don't believe I'm going to increase them because I think I can modify them in a way that will hopefully ensure the safety of the community. What I'm going to do in cause numbers 25 DCCR 0838 and 0839 is modify the bond conditions in those cases and order as a condition of bond that Mr. Fletcher is not allowed to drive, period, ever, any vehicle while these cases are pending. It does concern me, the prior allegations with regard to driving. We've got 2010 a crash, 2012 a crash, 2012 maximum speed limit issued, 2013 speeding over 10% over, 2016 speeding greater than 15 miles over, 2018 another crash, 2021 another crash, and here we are with a crash where I'm not going to get into fault, but there is a crash and we've got someone that has passed away and someone that is seriously injured. So that if I'm going to require that, I understand there may be work issues, and that is what it is at this point. That is what I'm going to order in those two cases.
And I can understand that, Judge, but I would point out that the same issues of fault that belie this case, we're also uncertain of what...
It doesn't matter to me.
We're
going to stop having crashes no matter whose fault it is. When there's a common factor and there's the same thing that continues to happen, I can't help but at least have some concern that there is at least some type of fault on some of those. You know, you don't get into that many crashes without something happening. Okay, so my job is twofold: keep everybody else safe in the community and to do what's right with regard to you and your rights as well. But I've got to keep everybody safe, and based on that history at this point, while the case is pending, unless something changes later with further order of the court, you are ordered not to drive. Okay. And so I think just by the nature of obviously that order, I'm probably inclined to grant the motion to set a bond in the probation case. And so I am at this time going to set the bond in cause number 21-37809. I'm going to grant the motion to set a bond. I'm going to set the bond in that case at, that's a possession. I'm going to set the bond in that case at $30,000. The condition of the bond is the same. You're not to drive any vehicle. And it doesn't look, I think Mr. Wilkerson is correct. I'm just looking at past administrative hearings that there hasn't been an issue with any type of positive drug screen or anything like that. And
Not administratively, Judge, but he is accused of, in addition to the manslaughter and the aggravated assault, accused of violating his probation with the possession of a marijuana case and also UCW.
so what I'm going to require is the condition of that bond on your MTRP case is that you wear a drug patch if you make that bond at all times. You'll have 24 hours from the time you're released to get a drug patch put on. You have to go change it every 2 weeks, on time. It needs to be on there, can't sweat off or whatever. You need to make sure it's on and it's testable every 2 weeks. Obviously, if there is a positive drug screen for anything in your system, it's a violation of all of your bonds, and you'll be right back into custody with Mr. Coleman probably telling me I told you so. So make sure you stay clean, make sure you do get it changed when you're supposed to, and all of that kind of stuff. So that bond condition is the same on all 3 of the cases. All the bond conditions are the same on all of the cases. No driving and drug patch on all 3 cases. Anything else?
Just procedurally, Judge, ordinarily, we would defer with these types of charges, new charges, we would defer the MTRP, we'll wait on that and proceed on the new case, particularly with how serious these are. However, in this case, I just want the court to know that we would be looking to go forward on the MTRP first.
Okay.
For a number of reasons. So we're looking to amend that MTRP. We'd ask that it be set prior to a disposition in the new manslaughter or aggravated
And you would be
assault.
intended on putting on evidence of those new offenses in that hearing? I would,
For punishment, the punishment part of it is,
I mean, to prove up the MTRP.
we have other things that prove up the MTRP, particularly the possession of marijuana, also the UCW, but there very well may be some additional testimony about those circumstances surrounding
So there-
aggravated assault and manslaughter.
There obviously appears to be some additional information, or maybe just because of the size of the cases, I haven't had an opportunity to review everything.
Yeah,
But
so-
there are some allegations that I'm hearing have not been at the forefront.
So let's do this. Obviously, you need some time to get all that information. If there's going to be an amendment, if you'll please take care of that quickly, make sure anything that's alleged in that Mr. Wilkerson gets any discovery with regard to any new offenses or alleged offenses that you intend to put. That way you guys can both have all the information. Mr. Wilkerson can do what he needs to with that information, and we'll set it for an announcement. And then we'll kind of go from that announcement on where to go next with regard to either the new cases first or the motion first. All right? Sound good?
That's fine.
All right, thank you. Y'all are excused. And thank y'all all for being here. I don't want anybody to think, I feel like we could cut it a little short and get that taken care of. All right, you go back with the bailiff.
Thank you, Your Honor.
But yes, sir, definitely have an issue with, all right?
I can understand that, and I did have an opportunity to browse.
You did?
I got
Okay.
them yesterday. I browsed through some of them. We did meet briefly yesterday as
Thank
well,
you.
so.
All right, sir, you are John Jones. And Mr. Jones is charged in cause number 25 DCCR 0523 with the offense of murder. And